New York Times bestselling author John Gilstrap.
Good morning.
Jefferson County Prosecuting Attorney Matthew Harvey.
Good morning.
I think we can go back to calling you Natalie Cladd this morning.
Yes.
You look very fall-esque, professorial.
Well, it is. I don't know if you noticed, but it's fall outside.
It is.
I love it. The weather's getting
Finally.
crisp.
Finally, it's my
Deer
weather.
moving.
Gilstrap's vest and your sweater underneath the jacket, I have to say, you guys are bringing up the real estate values in this room.
I was just seeing what kind of shirt you had on. It looked like it's a Nike
long sleeve tee.
coaching shirt.
It's our state championship shirt from last year.
Well, I think that's probably a good shirt for this next segment, isn't it? High school football?
Transitioning directly into high school football. And I'm going to bring up Colin's microphone, too, in the newsroom because he has firsthand knowledge of a lot of this stuff as well because of his role in our sports department.
Oh, he wasn't the ineligible player?
No, he did kick at Berkeley Springs High School, though, as a football player, right, Colin?
Yes.
He was the kicker. Via telephone, Joseph Joey Toots Ferretti. Good morning, Joseph.
Gosh, fellas, I wish we were going to talk about football, but I fear we're going to be talking about the court system.
It is indeed about the court system. I want to start on the federal level first because of the news of the Trump suits. And I saw that Jack Smith announced he's going to resign because you don't prosecute sitting presidents. The current president has felony convictions, or current president-elect, I should say, has felony convictions. And I'm hearing, Joe, that all those cases will be tossed out as well. What do you know about this?
Yeah, there's the two cases that we were following at the federal level, which is the case involving classified documents in Florida before Judge Eileen Cannon and the case in Washington, D.C., regarding the January 6th activities and whether or not President Trump had a part in facilitating those activities on January 6th. Those two cases are going to go away. Jack Smith was the prosecutor representing the Department of Justice on both of those cases. He knows he's going to be out of a job come January 20th, as do many other employees at the Department of Justice. So he is already filing motions with the judges who sit on those two cases to wrap them up. Now, it's not an easy process because unwinding a case of that magnitude that involved millions of documents in both cases is not an easy task. Those documents have to be returned. There has to be some semblance of organization and some orderly process to returning those kinds of documents and other evidence gathered. And, of course, in Florida, there were classified documents that were involved. So not an easy process to go through. It will take weeks to wrap it up, but those cases are going nowhere.
Let's move on then to a couple of things that they're discussing with great frequency now in Berkeley County. And the update now, which was forwarded to my email yesterday from Carla Trotman, Executive Director of the Department of Communications at Berkeley County Schools, also by Colin. And I trust by now you have read this too, Joe. In response, this is regarding the Spring Mills situation. Berkeley County Schools and Spring Mills High School, represented by Bowles Rice, filed an injunction today against, this would be yesterday, the WVSSAC to overturn its decision concerning the eligibility of a former student. We strongly believe the SSAC's decision conflicts, that was to strip Spring Mills of 4 wins, with the federal McKinney-Vento Act. This act mandates that Berkeley County schools must immediately enroll all students experiencing housing insecurity and eliminate any barriers to their participation in extracurricular activities. The SSAC's ruling disregards these requirements and unfairly penalizes all Spring Mills student athletes by forfeiting 4 of their 9 wins. With postseason football games for all 4 classes now delayed by the SSAC, we will keep our players and the community fully informed as we navigate this process and hope for a positive outcome. Joe, what do you know about the McKinney-Vento Act, and does it actually apply in this situation, and how does this affect ultimately the SSAC's power to rule on players on forfeiture of wins because of player ineligibility?
Well, in an attempt to answer your question, Rob, let me begin by saying that we have not been able to put our hands on the actual filing by Spring Mills. So we don't know what specific allegations, statements of fact, allegations regarding the law are embodied in their court filing. I hope to get that sometime today, and maybe we can follow up on it. But bottom line here is this. Spring Mills was penalized for allegedly using an ineligible player, for dressing that player. I don't know to what extent that player actually did participate in the games, perhaps a little bit. But regardless, there was an eligibility issue. Oftentimes, eligibility comes down to residency, questions of where that student is living and whether or not they're residing in the actual school district with whom they're participating on the athletic fields. So I'm sure that's what was behind all this, these problems at Spring Mills, and why they were ultimately adjudged guilty of having played an ineligible player and losing 4 games, forfeiting 4 games that they had actually won. They have filed yesterday, and I think this was late yesterday afternoon, this complaint alleging that the student involved was actually, in some respects, qualifying as a homeless individual or somebody who was insecure in terms of their residential status. And we can talk about home security and its definition, but bottom line here is McKinney-Vento is a law that was rooted back in 1987 regarding the Homeless Assistance Act of 1987. It was, I believe, under President Clinton. And the idea was to provide federal funding and assistance for the homeless. That was extended to students, to minors who should be matriculating in schools. And there was funding available now for public schools to identify students who were home insecure or homeless, living in hotels, living in vehicles, whatever, and to make sure that they had the ability to attend a public school and participate in all activities in that public school, including extracurricular activities like football and basketball. So we're guessing at this point, since we don't have the filing, but it's my belief that Spring Mills has at some point identified the subject individual who was deemed ineligible to participate as an individual falling under the protection of this federal statute, and thus he would meet the residential requirements that exist under the SSAC rules for participation, and he would qualify as a player on Spring Mills football team. Now, the devil's going to be in the details here because, again, without the filing, we don't know, but Spring Mills is going to clearly have to establish with any court who's reviewing this to what extent this individual was identified as somebody protected by this law. Is there evidence that he was homeless or there was some insecurity regarding his home? Where was he living? What living arrangements existed? And did the school, perhaps more importantly, did the school take the necessary steps to have this individual qualify for protection under the law by notifying state representatives who exist at the state board of education level to enact the protections of this law? Was there a local education liaison, which is actually identified in the statute? Was it an individual locally designated to assist this student? In other words, were some of the regulations and requirements of the act being followed by the school before they filed this petition claiming he was eligible to participate because of the law? So I think the school is going to have the burden of establishing that in some respects they had identified this individual as being protected by the law prior to his matriculation at the school, and that he was there because of the law. And that's going to be the burden they carry before the courts.
I got a question, Joe. So being allowed to go to a school under that act, is that different than being allowed to play sports? or once you're in school, you're every academic or extracurricular activities available to you.
Yeah, the law expressly states, Matt, that if you are attending a public school under the guise and protection of this law, you are permitted to participate in all activities, extracurricular activities of the school. You're allowed to be involved in the photography club, and you're allowed to do the dance team or do cheerleading, and you're allowed to play sports. So it's all encompassing in terms of what a student under the protection of this law can do if they're attending a public school.
Do you know if Spring Mills raised this previously with the West Virginia SSAC?
That's the question I have, is to what extent were the wheels already in motion regarding the dictates of this law and Spring Mills High School? Had they identified him as an individual subject to and somebody who would fall under the protections of the law, and did they go through the regulatory scheme to make sure that funding and representatives were involved in his situation to the extent that they can show that this is not something that they just pulled out of the air in order to reverse an SSAC ruling, but that there was ample evidence that they were utilizing the protections of this law and following the dictates of the law before the stuff hit the fan regarding this student's eligibility.
Well, it begs the question why Spring Mills even had to self-report if this student athlete fit into those parameters. But maybe
right.
they we don't know what we don't know. Maybe they sent it in as just to be safe. Here's this situation, and we think it applies under this exception, and the WVSSAC said no. Is this in state court or federal court?
This is in state court, and I believe there's a hearing set today at 3:30. I don't know which division.
Okay.
The hearing is set for. Again, we're trying to get our hands on the filing. The filing occurred yesterday, just before the close of business. And so we're trying to get our hands on it to figure out where this hearing is going to be.
And Berkeley County Circuit Court.
Good, good, Colin.
3:30, Berkeley County Circuit.
Do you know which judge it's in front of?
Yes.
Can you say?
Yes.
Who's the judge?
Judge McLaughlin.
Oh, your mother. Okay. Well, we got an insider.
As far as I can say.
We have an insider here, Joe.
Don't. So that's not even funny to joke about.
The stakes
it
here
is to me.
Are set.
I know, but she's not like that.
A win in this case, Spring Mills wins, then the 4-game suspension, whatever's the right word, would be those 4 games would be reinstated to their record. Is that what the stakes are here?
Yeah,
that's exactly the relief they're requesting with the filing, John. And if that does occur, you can add it to the stew that is brewing statewide regarding the ratings process and why we're not playing football this weekend.
Not only does it could it possibly restore those wins, but it would affect in a very positive way their ranking, their seeding, their playoff seeding.
I know,
but
go to
number 2.
Is there also the ripple effect of somewhere there's a school that as a result of this was, yay, we're now going to the playoffs, but then if these games are reinstated, then oops, we're not going to.
Let's go to Colin.
For Class 4A, everybody makes the playoffs because there's only 16 teams right now in Class 4A.
Was there any? Did they play any 3A teams during that stretch?
Do not believe Spring Mills played any 3A teams within the state, considered as 3A teams.
It could possibly affect the rankings, but Joe,
yes, it would affect the rankings, but it wouldn't knock anybody out of the.
Colin, would
playoffs.
A 9-1 record with Spring Mills, would they be the 2, or with the same record as Martinsburg, would they pass them as the 1?
I believe they would be the 2, is what people are saying. I don't have the exact numbers in front of me to know, but I believe what people have been saying is they would be number 2. I mean, either way, you want to be first or second so that you have home field advantage all the way through.
Yeah, it just changes
what state championship
changes what jersey you wear for the title game, basically, if you make it there.
But if it comes down, and again, sports ball is my life. But if it's really about the football, right, about the talent of the team. If they lose this case, they're still in the playoffs.
Yes.
Correct.
And then they can still win the championship.
Correct. But the difference is you play at home 3 straight games, or you travel anywhere in the state where the seating sends you, and this is quite the state to travel. Anywhere in the state. West Virginia does not do regional playoffs in football. It's open around the entire state, 1 through 16. Joe, what is the history of suits against the SSAC and its rulings in terms of the success in overturning an SSAC ruling?
Well, I know this well because it wasn't long ago that I was involved with an issue regarding player eligibility for the state championships, and I researched this extensively and got counsel from attorneys across the state regarding lawsuits against the SSAC. And bottom line is they are the heavyweight champ. And when it comes to prevailing before the West Virginia Supreme Court, I think rightly so in many respects, the Supreme Court has said, look, we have an administrative agency involved here tasked with the responsibility of managing and administrating all the rules and regulations regarding school athletics, and we will defer to them and their decision-making process as long as they don't act arbitrarily or capriciously, which are the legal terms, in terms of how they handle their business. They have a constitutional mandate. They are a creature of the legislature, and they are pretty much run by the principals of the schools across the state of West Virginia, and they are given due deference when it comes to making these decisions regarding any number of things, rankings, the conduct of the athletic contests themselves, and eligibility issues. Now, in this particular case, though, let me caution folks, what has been raised here by the law firm of Bowles Rice and Spring Mills High School is an important issue. There are many students in Berkeley County who qualify for the protections of this McKinney-Vento Act. And if Spring Mills can establish in a court of law that this student clearly falls within the parameters of that statute and the protections of that act, the decision of the SSAC can be reversed. They have lost before. It's just not often.
So if, in fact, Spring Mills prevails, then will the SSAC be in a position to then appeal that decision? Then that sets the whole appellate clock, and so we can see ourselves where the playoffs are being played in June?
Well, there is a concern because not only do you have this process going on with Spring Mills now, but of course you've got these other schools across the state who have various actions pending in the courts. And the SSAC yesterday at 5:30 p.m. filed their writ of prohibition before the West Virginia Supreme Court, where all of these concerns regarding rankings and school classifications are ultimately going to be resolved. I think the timing of this, John, to your question about whether we're going to be playing in June, the timing is going to be such that I can expect the courts to be working through the weekend, and I think we're going to have an answer Monday or Tuesday of next week because this will be on an expedited track. And my guess is that the playoff system will be set by next Friday.
So let me see if I understand this correctly about the seeding. So at the beginning of the year, the SSAC said they redid the classification system. So some, like maybe 1A teams went up to AA, but they had a 1A schedule. And maybe a 3A team went down to AA with a 3A schedule. So that's how you got 3 and 7 teams going into the playoffs over 7 and 3 teams and started this. But didn't they change back by a court, like an injunction?
Yeah. Here's what happened was we went through a reclassification actually in 2023, which we do every 4 years in West Virginia. Schools started arguing that the reclassifications were not done correctly and we should be in this class or that class. So there was a lot of legal maneuvering and a lot of appeals within the SSAC system, because they have a board of review and all that. Eventually, August of this year, before the football season, the SSAC reclassified about approximately 20 schools based upon all this maneuvering that took place, and said, okay, we're starting the season. Here are the classifications, and here's how we're going to do the ratings throughout the year. Well, I recall coaches saying back in August, hey, this is going to be a problem. We already set our schedule to play all Quad A teams, but now some of those Quad A teams became Triple A teams on our schedule. We're going to lose ranking points because that's part of the rankings process, and so we're going to suffer at the end of the year. So some of the coaches already had anticipated this problem. Lo and behold, we get to the end of the year, and the rankings come out officially for who's going to host playoff games and who's going to play whom. And some of the schools said, we told you this was a problem. Now we're going to go to court and argue that you shouldn't have adopted a new rating system for the new classifications after our schedules had already been set. That's unfair, and we went to courts to fix it. So ultimately the question before the West Virginia Supreme Court is, which classifications do we rely on for the rankings system? The one that predated the August 2024 changes, or the ones afterwards that the SSAC wants to apply?
Colin has a question for you regarding the status of the student and his age. Colin, go ahead.
I know the student in this instance was not a minor. The kid is, I believe, when he enrolled, 18 now, 19 years of age, Joe. So does this act still, I guess, trickle over to cover him as a student is the question.
That's a very good question. I have not researched that, Colin, but that's an excellent question because part of the extension of this Homelessness Act from 1987 to the school systems and to minors, okay, minors are people who are under the age of 18, whether or not this individual would still qualify is a question I think that the court's going to have to wrestle with. Now, I do know that there are 18 and albeit even perhaps 19-year-olds in high school still. So to the extent that this individual has not completed a high school curriculum, has not graduated from a public school, perhaps that individual still qualifies. But that's a good question, and I don't know eligibility-wise under the terms of the law whether or not this individual would still have those protections.
Joe, if because of McKinney-Vento, a student transferred into your school system and he wanted to play or she wanted to play a sport, but you did not permit that student to play because you weren't sure about their eligibility, could that student then sue the school district for potentially violating McKinney-Vento?
Oh, no question. No question. The aggrieved student would have a cause of action arguing that this law, because it expressly allows these students who are attending under this designation of being homeless to participate in all extracurricular activities. So even if a school was trying to be proactive or protective in terms of eligibility issues and denied that student the ability to participate, that student would undoubtedly be able to press that issue in the courts.
I don't know the facts, but that seems like